The Next Breast Thing podcast is primarily funded by the American Society of Breast Surgeons. The support of sponsorships helps us offset some production costs. ASBRS does not endorse or co-promote any company, product, or service mentioned.
This episode of The Next Breast Thing is made possible in part through the generous support of Myriad Oncology and from Solventum Prevena Therapy.
Myriad Oncology provides a portfolio of advanced genetic and tumor genomic testing solutions, including risk assessment, screening, tools to aid treatment guidance, and survivorship planning. The Myriad Oncology offering is designed to meet the unique needs of oncology specialists and their patients across each step in the patient care continuum.
To learn more, visit myriad.com/oncology.
Solventum Prevena Therapy has demonstrated a significant reduction in surgical site complications, infections, and readmissions. Take a proactive risk management approach. With Prevena Therapy, learn more at Prevena.com. That's Prevena.com.
Hey listeners, want us to let you know when new episodes are available? Simply hit the subscribe or follow button on the Next Breast Thing podcast, wherever you listen to podcasts.
On this episode of The Next Breast Thing,
Take 2 on medical malpractice. There's so many. So, Angela, you get the dreaded phone call from your risk department. What do you do in that first 24?
We had a case that was going on for 2 years before it made it to trial. He did not tell his family that he had been sued or was going through that.
And we wonder why people want to leave medicine after being sued. How do you get through? How do you survive?
One thing that does bring you into a lawsuit just as quickly as anything else is other people.
Does the jury system really work?
I'm not gonna lie, trial is not a good experience, but you can look at it as
this is Carla, Ellie,
Michael,
Susie,
And Susan. Welcome to The Next Breast Thing, a podcast by the American Society of Breast Surgeons for the entire breast community.
We're a group of devoted surgeons from different parts of the country,
inviting you to journey with us into the science of breast
through the heart and soul of our breast community.
From advances in procedures and patient care to personal transformation, we're here to support you.
So, if you're part of the breast community and can't seem to find the answers, this is the Next Breast Thing.
As our listeners may remember, we recorded a podcast on medical malpractice with Angela Klein, and there was only so much we could cover in one episode of the podcast, so we've invited Angela back for Take 2 on medical malpractice. There's so many things to ask about this topic. It is our greatest fear once we become attendings is, will I get sued? When will I get sued? What do I do? So Angela is back for part 2 to really walk us through this process.
thanks for having me back.
So Angela, you get the dreaded phone call from your risk department, or you get served in your office. What do you do in that first 24 to 48 hours? What should we be doing?
First off, don't panic.
Easier said than done.
Don't pass out on the floor. Call your insurance carrier. Talk to risk. As we talked about in the last podcast, they are your friends. If the notice of the lawsuit did not come from them and it was something that you received directly, let your risk department know right away. Chances are then they will reach out to your insurance carrier to report that service of a complaint, and the ball can start rolling from there. Now, in the instance where you may have been served personally, definitely contact risk. You are always free to call your insurance company as well yourself. I think it's better to filter that through your risk department if you have one. And then they will call and get one of their panel attorneys on board to give you a call and assist you. So try and look at it as a business venture, as another chore on your list. I need to call this person. I need to call this person. I need to set this up. What do I need to do next? And that's what we're going to walk through. You start with that risk department. You start with calling your insurance carrier. They will have someone call you back immediately and start to walk through that process. What happened? Send us a copy of what's called a complaint, and we'll talk about that in a moment. So remember that it is risk's job and their interest to make sure to get someone on board as quickly as possible to assist you.
Should we be talking to our colleagues about this, especially as a young attending? If this happened to me, I would ask my mentor first thing. That's always my first person to ask something about. What are the rules around that, or what should we do if we are having this happen to us?
No, do not talk to your colleagues about this. Once you are sued, you need to circle the wagons, I guess is the best way that I can phrase that. There are only certain people that you can talk to that are protected by a privilege once you're in a lawsuit. What you don't want to do is start talking to your colleagues, your friends, your neighbors about this lawsuit, details about it, what you remember about the patient, complain about the situation, because all of those conversations are potentially discoverable down the line. Whether it's in a deposition of those people, in written discovery, all of which I'll tell you about in a little bit. But those conversations can be discovered and asked about, and you can never be sure that the person that you were talking to is going to remember the conversation the same way you do. And it may not be helpful. There are people that are protected under privileges. Those would be your spouse. That would be a therapist or a counselor, a spiritual leader like a priest or a pastor. You can talk to your defense team. So when you call your insurance company, your adjuster there, the attorney that they hire for you and their staff, those conversations are privileged and protected. Outside of that, they are not. So we highly discourage you from having those conversations. That can be difficult. This is a difficult process, and it's hard to not want to talk to everybody about it, but it is in your best interest to try and keep that circle of people small.
So just to segue for a moment away from the legal side of this, we read the dreadful paperwork as to how horrible we are and what damage we've done, and then we're completely isolated because we're not allowed to speak to anyone about this. And we wonder why people want to leave medicine after being sued. How do you get through? How do you survive?
That is hard. There is nothing like getting that piece of paper. Sometimes they are 50 pages long with 300 paragraphs of everything, every bad thing you could possibly have done to someone and how it's destroyed their life. There is no easy way to read that. There is no advice I can give you that's going to make that less painful to read. What you need to remember in that moment, it is that plaintiff's attorney's job to make it sound as bad as it possibly can. And the vast majority of the descriptions in that complaint that you were served with are probably exaggerated or to some extent not even true, or they're written in legal terms that they need to use in order to prove their claims or to prove damages. So try, easier said than done, of course, to take that step back and recognize, I know it's their job to make this sound as bad as possible, and man, did they do a good job. That's what you're going to think, because reading those complaints is difficult. I would suggest, as I would tell my clients, there are a lot of resources available. And what I don't ever want to see, to kind of touch on what we talked about last time, my passion for this line of work is getting you through this. It's not just the legal part of getting you through it, but also the mental part and the practice part. And I have resources available that can help you. Your insurance carrier has resources available that can help you. A lot of carriers have programs where they will pay for therapy for someone to talk to about all of this. Talk to your spouse. I had a client once who we had a case that was going on for 2 years before it made it to trial, which is not uncommon. He did not tell his family that he had been sued or was going through this process until the night before trial. I was just shocked and very upset because he had been shouldering this himself for 2 years without talking to anyone, and I had no idea. I don't ever want anyone doing that. I am available as your attorney to talk to you whenever you need me, but you also have your spouse. You have a therapist. Take advantage of that. There are programs out there that will pair you with physicians who have gone through this process all the way through trial. Their job is not to talk to you about the medicine or the facts of the case, but more to talk to you about the things that I can't help you with. How did you manage your practice? How did you look your patients in the face every day and not feel bitter about what's going on right now? How did you manage the workload and being in a lawsuit? How did you manage your deposition? What did that do to you? What helped you get through it? Trial is a roller coaster of emotions. One day, everyone is testifying about how horrible you are. The next day, our experts are up testifying about how fantastic you are. It is a hard thing to sit through. These physicians will have been through that and can tell you how they dealt with it. Take advantage of those programs. This is not the time to be a hero.
Once we get through that first 24, 48 hours, what do we expect from there? I mean, you've said 2 years and I'm like doing a big swallow, like, holy cow, that's a really long time. Is that normal? Is it sometimes shorter? Or what's the next step after that 24, 48 hours? What are you doing and what am I supposed to do?
What we're doing together as a team in that first couple weeks of you having been sued is we're going to come up with how to respond to that complaint. Here in Colorado, that's called an answer to the complaint. Or there are certain times when the complaint is not legally valid or there are different things that are legally wrong with it, so we can do a motion to dismiss. We're deciding how to respond to that complaint. And you and I are working together on that very closely. I'm going to have you into my office or if necessary on the phone, and we're going to sit and we're going to walk through every single one of those paragraphs in that complaint. You're going to tell me how you feel about it. I'm going to tell you how we respond to it, and I'm going to tell you why we're not worried about it. Or if we are worried about it, we're going to talk about why and what we're going to do about it. So we're going to walk through that probably ad nauseum, so that you feel comfortable in knowing what these things mean in the complaint and how we're going to address them. We're going to set out a plan for whether it's a year or whether it's 5 years. We had a trial last fall on a case that was 7 years old by the time we got it to trial. Now, some of that was COVID. When the courts were closed, we got bumped a few times. That is definitely an outlier, but it can happen. We're going to come up with a plan to get you through that time frame. What do you need to do? What do I need to do? How often do you want communications from me? One, that is something that I think you should talk to your attorney about at the outset of the case. Some people want a check-in every week. They want every document. They want to check in a status every week, and I'm happy to do that. Some people only want to know when something relevant has happened, something big has happened, or when they need to be involved. The reason I prefer that is I don't want this on the forefront of your mind every day and every night. I want you to lean on me and my staff to do the day-to-day and only have to contact you when I need you for something. I want you to go on with your life. But that's a conversation that you should have with your attorney at the outset, is how involved do you want to be in terms of the communications back and forth? And you should always feel comfortable reaching out to your attorney if you're getting too much information or you're not getting enough. This is your case. This is your livelihood. This is your mental health. And you should expect your attorney to do whatever they can to assist you in all of those ways. So we're going to walk through that plan. We're going to file an answer. From that point, we move into what's called a discovery phase of the case. And this is a part of the case where we can issue written questions to the other side, trying to get more information. They can do the same to us. That is one part of the case where we need your engagement more. It's a lot of hurry up and wait in a lawsuit, especially for the physician, not necessarily for me, but for the physician. It's you might not have anything relevant to you happen for 2 or 3 months because I'm collecting medical records. I'm reviewing them. I'm seeing what we need to do. None of that necessarily involves your input. When I get discovery, then I'm going to need your input. When it's time then for depositions, that is a huge piece of the case where you need to be very, very engaged. And that is the best thing that you can do once you're sued is be present, be engaged, ask questions of your attorney.
When you say be engaged, what does that mean? Does that mean we're doing background work? Does that mean we're giving you the questions? I mean, we have the medical knowledge, you have the legal knowledge. Where does that blend together?
Great question. So, no, I don't want you doing background work. That's part of me wanting you to be able to, at least to some extent, put this in the back of your mind. We're doing the background work. I'm looking for experts during this time frame to support the care. They're giving me a lot of that medical background that I need to understand what's in the records or what the allegations are, answer my questions generally about the medicine. I will be in touch with you when I have questions as well. When I say be engaged, that's what I mean, is when I reach out to you and say, your note says this, is this typical? Or what would the typical expected recovery time be if not for this complication? How much additional time did this patient need physical therapy or time off of work? I'm asking you those questions because you're the best person to ask. So those are the times when I need engagement from you. I don't want you doing research behind the scenes. I don't need you running around finding experts for me or providing me written questions. I will usually ask before I depose the plaintiff in a case or their experts. I will typically sit down with my client and say, what would you like to know? What do you think is an important piece of information here that we need to hash out? Sometimes I'll have already thought of it and sometimes I haven't. But you are right. You have the medical expertise. And while I have an expert in my ear giving me some of that as well, no one can tell me as well as you can what happened.
Is part of the expert to help understand what is standard of care and if there was a deviation from that standard of care?
Absolutely. Many states have requirements that when you sue a medical professional, you have to have expert support for that care. Colorado being one of them. You have to have an expert that can say, yes, something was done wrong here and here's what it was. So what I'm doing is hiring an expert to look at the medical records and tell me objectively, actually, this wasn't great. This is what should have happened. That helps us determine whether we want to move forward in defending the lawsuit or whether we want to talk about potentially settling it. Or hopefully what I'm getting back is an expert who says, no, this was all reasonable and appropriate and within the standard of care. What I'm looking for with an expert is often very different than what a plaintiff's attorney is looking for in an expert. And largely what we see with plaintiff's experts is it's a credentials issue. They want to say they're from somewhere out of California or Cleveland Clinic, or occasionally there's a Harvard in there. And it doesn't necessarily matter what they say. They just want someone to say at a high level, this is what was done wrong. And I know that because I'm from Harvard. I had an expert once that literally in trial, that is all he said the whole time. Well, at Harvard, we do it this way. And at Harvard, we do it that way. And at Harvard, we wouldn't have done it this way. The plaintiff's hope, of course, being that the jury would be so enamored and persuaded by the fact that this expert was from Harvard that they wouldn't realize that he actually said nothing of substance.
How does that work? How did it work for the attorney?
So we won the case and we always talk to a jury. Anytime that we're allowed to, we'll talk to the jury after the case. What worked? What didn't work? What did you like? What was persuasive? They hated this expert with a passion and commented on the fact that he brought nothing to the case and it was more of an arrogance and a credentialing and he just was hired to say Harvard. Juries are smart for the most part. I don't think they get enough credit. Now, having watched some jury deliberations and mock trials, it can be terrifying in terms of the conversations they have and how they get to where they're going. But the vast majority of the time, they get to the right place. They're smart enough to know experts are hired because we know they're going to say what we need them to say to support our care. With plaintiffs, it's the Harvard. And the jury hated it. What I'm looking for is usually someone local to where the case is, someone who's going to explain the medicine, not just stand up there at the lectern or on the podium and say everything they did was reasonable and appropriate, and I can't even believe that they would suggest otherwise. The jury is not going to have the medical sophistication that you obviously as a physician have, or even that I have as your attorney. we're teaching them the medicine. We need them to understand why you did what you did. What was the thought process? Why was this reasonable? What was the intention in what you did? And they need to be able to explain that to a jury. So I'm looking for someone who's personable, who's articulate, and who can explain that on a level a jury will understand without being condescending. That's what I'm looking for in an expert. I want someone who at the end of the day, when I talk to the jury, hopefully after a win, says, can I get that person's information? I want them as my doctor. I want them to say that about my client too, and that happens. But that's what I'm looking for. Not that they were so impressed that they were from Harvard, but that they taught them something and that they could tell that this person's passionate about what they do. And they really understood the medicine better after they explained it.
Angela, I have a question about the medical experts. When you're sourcing them, do you source them from all over the nation? Or is it like if you're practicing in New York or LA, you're going to have access to all these specialist expert witnesses versus maybe if you're in the middle of Kansas, you actually don't have access to all these specialists. So I was just thinking, like, we are very specialized in breast surgery and the knowledge that we have changes constantly. Every year there's a new practice changing paper. And I was thinking, gosh, I'd be really worried if I was in the middle of Kansas and maybe I only have access to a general surgeon expert witness who hasn't done breast in 30 years. If you have maybe an expert witness who doesn't agree with you, or how does that work?
As I said, I try to always source locally first. It just relates better for a jury if a local doctor can explain the local medicine. I say local, we'll use Colorado as an example since I'm based here. There's a difference between something happening at Denver Health versus something happening at a regional hospital in the middle of the mountains where there are no specialists to deal with something. In those cases, I might want an expert who is better suited to talk to rural medicine than someone who's never been in a situation where they didn't have 80 specialists on hand in every machine they could possibly ever want to use right at their disposal. You want to tailor it to the needs of the case and the actual situation and factual situation that you have. I don't want the big city expert talking to me about what my rural doctor had to work with during their surgery. So yes, we will absolutely source nationwide, especially when we've got something that's so specialized. I have a case right now with a doctor who there are maybe 4 people in this state that do what he does. That happens fairly frequently, and it's not unheard of at all. I just prefer to start locally if I can.
So after we do this discovery process and you decide you're going to defend the case and it gets to a deposition, what does that mean for the physician? Is it audio? Is it video? Are you seeing people face to face? What's the setup and what do we say or not say during that period?
Depositions, in my opinion, are probably the most important part of your lawsuit and the defense of your lawsuit. And as such, we spend a significant amount of time preparing for a deposition. Your deposition may be on December 30th. We'll spend months ahead of time in several different prep sessions where I will grill you like a plaintiff's attorney. We will go through every medical record. We will talk about every topic that could possibly be covered. We'll talk about the pitfalls of falling into some of the tricks that attorneys use. And I don't say just plaintiff's attorneys because I use plenty of tricks in my depositions as well. People hate awkward silence. That's a big one. So you ask a question, I'll counsel you to say if it's yes or no. You may say no. And then I'll sit here and shuffle my papers for a while in this awkward silence, and you need to fill it. And that's how I get you to talk for another 20 minutes and say things you shouldn't say. So we talk about some of those little tricks and how to get ready for them. In some cases, there are consultants so we can bring in to help prep you as well. We have someone that we use occasionally that I refer to as the physician whisperer. He can take the worst witness and turn them into an A+ witness in a weekend. So we have a lot of resources available and we use them all because the point of the deposition is, of course, to get the facts out, to see what we're going to say or what our position is at trial. But what I want to know in a deposition as well is how are you going to present? Because 90%, that may be exaggerating, but to me, 90% of how a jury trial goes is how you present to a jury. Does a jury believe you? Do they find you credible? Would they want you as their physician? Do they believe that you listened to the patient? Did you have a plan in place? If you can persuade a jury that you care, that you're genuine and sincere, and you can articulate your thought process, a jury's going to side with you 9.5 times out of 10. And part of the reason for that is every juror, they're a person. They have medical needs. They have physicians, and they want to believe that their physician cares about them and listens to them. And it's hard to wrap your mind around the fact that maybe your physician isn't listening, or didn't care, didn't have a plan for your surgery, things like that. So they want to believe that you care and you listen. And so the vast majority of the times, my clients are those people, and it's not a challenge. But every once in a while, you have that client who may be an excellent physician, and the medicine may have been perfect, but they can't articulate for themselves what they did or why they did what they did. And so you really need to put the extra effort and resource into helping people compartmentalize and articulate what they did. So all of this is to say this deposition is the time when everybody gets to see who you are, how you're going to present, will a jury like you? Sometimes that can make all the difference in whether I can get you dismissed from a case or not. Likewise, I'm doing the same thing when I depose the plaintiff, the patient in the case. I want to see how they present. Are there buttons that are easily pushed? Do they come across as greedy or over emotional? Are they sympathetic? Are they nice people? All of that plays it into our strategy for trial. And sometimes I can get a case dismissed because the plaintiff presented so poorly in their deposition that their attorney doesn't feel it's worth pursuing anymore. These are why depositions are so important. That's always my goal, to have a deposition go so well that I can convince the attorney on the other side that this is not going to be successful at trial. Our success record in the office right now is 100%. With one of our main clients, it's 92%. Again, because juries want to believe in doctors. And so if I can persuade or have you come across as the physician you likely are, the kind, caring, compassionate physician, it makes it much less appealing to a plaintiff's counsel to move forward with the case. And that can also be because in several states, Colorado included, if you go to trial and lose, you're responsible for the other side's costs. If you have a case that is 9 times out of 10 a loser, you might want to walk away before losing at trial and having to pay the other side's costs and fees.
So I have a question about the whole legal system. Earlier, you said the jury normally gets it right. They don't have the deep medical knowledge, but they get it right. So if so much of this is based on likability and how good a witness you are and your body language and all that, does the jury system really work?
I truly believe it does.
I hope you believe that. But how do we believe that?
A jury does listen. When you listen to how a jury deliberates or the questions or comments that they have after trial, they were paying attention and they were able to pick up on what was important. They're able to pick up on the fact that, again, you had this plan, you had this process, and medicine, not a magic wand, like I always say. Juries are smarter than we give them credit for. Sometimes you have to go through an hour of deliberations where they're talking about how they didn't like the pantsuit you wore that day, which is terrifying.
That goes to my point. It feels like this is theater and the best actor or actress wins.
A trial is a story. Every time we get a new client in the door, a new complaint in the door, what I'm looking at from the day you come across my desk is what story do I want to tell a jury at the end of the day. And I work backward from there. What information, what evidence, what experts do I need to tell this story? And that's exactly right. To some extent, it is theater. It's me, or you're getting up there and telling your story and trying to convince a jury that your story is the right one. May the best storyteller win.
That's how I feel about the legal system so often is it could go into acting or it could go into law. You have an expertise, but acting has to play a role in a jury trial.
It makes me think of my cousin Vinny in jury duty and all these different things. But yeah, they're.
I don't want to say you're aging yourself, Susie, by talking about my cousin Vinny, but I know exactly what movie you're talking about.
No, I've always wanted a Marissa Tomei witness up there talking about the car bodies and tire marks. And yeah, that is exceptional.
What is trial like?
Trial is stressful. I'm not going to lie. As a trial attorney, it's my Super Bowl where everything that you've worked on for your client comes together. For the physician, however, there's nothing pleasant about it. There is no sugarcoating what a trial is. It's a roller coaster. Plaintiffs have the burden of proof, so they start. So the first week of any given trial is likely witness after witness after witness talking about what you did wrong, why you did it wrong, how you ruined these people's lives, how they're never going to be the same. It's very, very hard. Then they're done and it's our turn. And every day is about how wonderful you are and how everything you did was appropriate within the standard of care, bolstering you as a physician. And so it is literally every day, up and down until the end. And sometimes they're weeks, sometimes they're 4 weeks, and you have to be there every day. You're asking a jury to be there every day to listen and to make a decision. So you need to be there every day. It's a lot. So I'm not gonna lie, trial is not a good experience, but you can look at it as this is my opportunity to defend myself and advocate for myself and not just roll over and say, it's easier for me to say, let's just settle this case and not go through that emotional roller coaster of trial. There is value in it, and it is in defending yourself and in doing so, defending the industry. What I am always interested in terms of how we decide what cases to settle and what to move forward is I will always defend good medicine, always defend good medicine. But what we don't want to happen is for this to become the auto industry, the personal injury industry, where if you're home during the day, you've seen what every third commercial is a personal injury attorney telling you to call them because you can get money for whatever injury you've suffered in a car accident or whatever it may be. And the problem with those is that it's often easier for those types of insurance companies to settle those cases than to hire attorneys and go through the process of defending that care. That's why you see so many personal injury lawsuits. We don't want that to happen in the professional liability arena for physicians. There are consequences for physicians to being sued. There's reportability, there's credentialing and licensing and the national data bank, all of these different places where things may have to be reported. So there's consequences to you for settling or for getting a verdict against you. We don't want this to turn into a situation where you're just constantly getting sued because they know you're going to settle for some small amount right out the gate. We're going to defend you. And that's why it's important to me that when appropriate, we go to trial and we defend your care because you're making the field of medicine better for your colleagues. Now, that being said, the vast majority of lawsuits never see the inside of a courtroom. They're dismissed or they're settled. In any given year, we could have 14 or 15 trials scheduled for the year, which is physically impossible. But we don't stress about it because 90 to 95% of those are going to go away. You may end up going to trial once or twice a year. So the vast majority never actually go to trial, but you always have to prepare them as if they are.
What are constructive ways to use the experience to strengthen our practice, to strengthen our resolve, and reduce our future risk after going through this terrible experience?
In every claim, in every lawsuit, there's something to be learned. Whether it is the way that you communicate with the patient, how often you communicate with the patient, understanding that, hey, maybe if I had taken that 5 minutes after work that day to call and check on Ms. Jones, we wouldn't be here with her complaining that I abandoned her or didn't care about her and now she's suing. Your documentation is probably where the majority of that is going to fall in terms of how can I better document in the future, not over documenting, but what you document, more targeted documentation to prevent you being in a lawsuit later on. One thing that does bring you into a lawsuit just as quickly as anything else is other people's documentation. So as a surgeon, if you are seeing a patient who has been through another surgeon, another specialist, and you don't agree necessarily with the plan of care that they prescribed for this patient, don't put that in your chart. Try and document a little bit more neutrally. Like, after my visit with this patient, I've decided the best course of action is XYZ. You don't put in your chart, I disagree with provider Smith's previous approach, and I'm going to change the medication to this, or try this surgery. What you've done in that instance is almost guarantee a lawsuit against that physician and make yourself the key witness in that case.
This conversation has just been so interesting. And honestly, even though we are ending part 2, I could go on to like part 5, but we'll stop torturing you. This has been great. Before we go, are there any final thoughts you'd like to share with our breast community?
I want to express my appreciation for what this community does for its patients. My mother had breast cancer, and thanks to her amazing providers who provided not only great medical care, but also great emotional support, she's still with me today. And she remembers every one of those providers and every one of the encouraging words that they had. I have a close friend who's now going through a series of surgeries, breast surgeries for cancer, and watching her go through this and the amazing care she's receiving, the support she's receiving from her surgeons, it makes me proud to do what I do. And so I just want to express my appreciation for everything that you all do.
Well, right back at you, because we appreciate what you do in protecting us, in helping us keep our sanity during our darkest days, if and when we get sued. So to all of our listeners throughout the entire breast community, we are so excited you've joined us once again on this journey, and we'll see you next time on the Next Breast Thing podcast.
We look forward to connecting with you on the next episode of The Next Breast Thing, a podcast by the American Society of Breast Surgeons for the breast community.
Also, join the conversation on our Facebook group by searching the Next Breast Thing podcast group on Facebook.
Finally, the content within the Next Breast Thing podcast represents the views, thoughts, and opinions of the co-host and may not necessarily reflect the views, thoughts, and opinions of the American Society of Breast Surgeons.
Until next time, this is Carla,
Ellie,
Michael,
Susie,
and Susan. And always remember, if you're part of the breast community and can't seem to find the answers, this is the Next Breast Thing.